Welcome to Looking at Legal Stuff. Today we have part one of an evidentiary hearing in the case of a couple where both mom and dad are motioning the court for sole legal custody of the children, with each of them claiming a laundry list of complaints as to why the other parent shouldn't have it. Dad testifies first, and he has a never-ending list of problems and complaints that he claims are just some of the reasons he needs to be given sole decision-making over the children, including problems with the children's health and hygiene, being late for pickups and drop-offs, not having their own space at mom's house, homework not getting done, mom's dependence on screens to keep the children entertained, and poor school attendance, just to name a few. Mom's lawyer responds with a lengthy list of her own accusations against Dad, claiming coercive control, verbal, emotional, and financial abuse, penalizing the children when he's upset with Mom, and Dad's drug usage. She also claims that Dad attempted to get a TRO in the case using his allegations and was denied. What does the judge think of their competing motions? Let's find out.
Okay, the 20th District Court of Travis County is now in session. The Honorable Jessica Mangrum presiding.
All right, good afternoon. Welcome back to the 200th District Court. We are here again on cause number D1FM12-002379. And let's go ahead and get the announcements again before we proceed.
Your Honor, Haley Hoburn, representing respondent and counter petitioner Jacqueline Wolf, ready and present to go.
Okay. And do you still believe you're going to need a full day, or do you think we might be able to complete this hearing this afternoon?
We have not gotten any sort of discovery. Everything that both parties are using here up until this final hearing, my client was pro se, so no discovery was exchanged. I don't know how much time the petitioner is anticipating using. We didn't get a witness list, so I can't guess on that side. For our side, we have, I believe it's 5 witnesses plus the counter petitioner and quite a few exhibits. So I anticipate that if we go through all of that, we will end up using our full 3+ hours of our half of the time.
2.5, not 3.
Sorry. Yes, ma'am.
Okay. All right. And for the other side?
Your Honor, my name is Jeff Wolf. I'm the petitioner here. I too agree with the fact that we're going to need the full time, half hours. I don't have any witnesses to call. I have ample evidence that I want to submit and make sure it's heard and seen. Outside of that, I'm ready to go. But I do fully feel that we're going to need that full time based on everything.
Well, we're going to go today till about 5 o'clock, and then we'll talk about whether what to do about coming back, because I understand there's at least one conflict with tomorrow morning's schedule. So we'll just do the best we can with the time we have today, and then we'll talk about tomorrow, the next day. Okay?
Yes, Your Honor. And I should be able to do tomorrow afternoon. If we're doing 3 hours today, I should be available by 1 or so tomorrow, is my anticipation after the hearing in the morning.
Okay.
The problem we have is that the witnesses have taken off of work in order to participate, and we might be losing some witnesses by tomorrow afternoon.
Okay, well, not a lot I can do about that. And on the family docket, not everybody gets called on Monday. Some people get called on Tuesday or later. So it's a holiday week. We're just going to do the best that we can. All right, Mr. Wolf, you're the petitioner, and I think it's your modification. And then there's a counter motion for modification. So I'm going to go ahead and ask that we start with opening statements first. That's just a brief opportunity for you to tell me about the relief you're seeking and why. And then we'll go to the respondent, and then we'll start with the evidence. You may proceed.
Thank you, Your Honor. I'd first like to offer an apology to the court, basically, for my illness on November the 1st and it prohibiting me from being here. In no way was I meaning to waste the court's time, despite any accusations, of course, that were brought on by opposing counsel. It's become habit forming through this process. The amount of time I've spent the focus and the energy combating basically false accusations by the other party. But today I do promise the court that I will keep my testimony focused on the true reason why I'm here.
Okay.
And
I'm sorry, Mr. Wolf, I've got to interrupt you. I failed to do a couple of things before we got started. You're representing yourself, so in addition to serving as your own lawyer, you're testifying, even though this is an opening. So I need to go ahead and swear you in.
Yes, ma'am.
If you'd raise your right hand and be sworn. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. And then the other thing is, typically in hearings such as this, there is a request to invoke the rule, because normally we ask that witnesses remain outside the courtroom until they're called to testify, so they're not influenced by what may or may not be going on in the courtroom. Is there such a request at this time?
Yes, Your Honor.
Okay. And so, Ms. Hobron, you're the one who has the witnesses. Will you just identify for the court everyone who needs to be sent back to the virtual waiting room?
Your Honor, I'm trying to see if everyone that we have is actually here. It looks like we are missing at least one witness who is a little bit older, less familiar with technology. I think she's probably having difficulty signed in. That we can help her out later. We have Desiree Martinez, Nick Barrientos, Erica Sheridan, Jacqueline Wolf, and Lori Watson present to testify. And we will be invoking the rule.
Okay. Well, I'm gonna, of course, Ms. Wolf will stay in the courtroom since she's a party, but all of the other witnesses are going to be sent to the virtual waiting room. And before I do that, let me just admonish everyone. If you are going to be called as a witness in this case, you may not discuss the case with either party or any counsel while the hearing is going on. Furthermore, you are prohibited from watching the court's YouTube live stream. If I find out that anyone has done either of those things, texted with a party, anything like that, it's well within my discretion to prohibit you from testifying in these proceedings, and I probably will do so. So follow my instruction and simply wait in the waiting room until you're called to testify. Okay. And Ms. Seeger, if you could move all of the non-party witnesses to the waiting room at this time. Okay, let's see. All right, that has been accomplished. Now we are in the virtual courtroom. All of the witnesses who are not parties have been removed. And Mr. Wolf, now you may proceed with your opening.
Thank you, Your Honor. Basically, throughout this process, it honestly broke my heart to see that my ex-wife's motives, after seeing the discovery that she's brought forward, has appeared to be more for reimbursement of funds. You know, one thing, when my children were born, I made a promise to them that I would always make them first and foremost and keep them a priority when making decisions. Despite how different our situation is than what I anticipated, that goal is one that remains constant as I continue to prioritize my boys in their best interests and well-being. In the 11 years we've been divorced, I had hoped that things would get to a point that it would be improved, and things would improve for them, that we would all come together and work towards a common goal. But life happens, and what has transpired over these years of being divorced, I feel like I owe it to my children to be here today and do what I'm doing, because I've been asked by them and given a blessing by them to do so. I want to let you guys know that this isn't something I'm doing for me, despite of her. It's something I'm doing, again, for these two boys. But in order to do this, I had to compile a substantial amount of evidence in order to show the differences between my ex-wife and I and the way we parent, our standards of living, and basically how and what we put our focus and energy towards. With Brayden now being 17 and Connor at the age of 13, I know how imperative a good role model is. You know, focus needs to be on education, future planning, establishing and maintaining good habits and instilling valuable life lessons to make sure that my kids are making the right choices going forward. My brother and I think I have a lot of similarities because my brother and I share the exact same age difference. And we were fortunate to have good parents growing up, which has kind of instilled my values and my reasons for how I parent my children. But it's been challenging instilling all these positive ideals with my kids, with two split households, with two completely different worlds. I faced issues and concerns with health and hygiene, especially with, these ages, and reinstilling just basically good habits. I've faced trouble with, ensuring that they're dropped off and picked up for school on time, or making it to school for that matter on time. And I will show that within my exhibits. Stability and structure is a big thing for children, and receiving unconditional love and support in that home is not always there, and it's something I try to focus on here. So I try to make it a priority for my kids to always have a safe place where they have resources to study and practice sports and band, and an environment that basically fosters creativity and focus. With that being said, I've worked really hard to create that strong bond with my children as well, to make sure that as they grow up, they trust and can open up to me, that they feel comfortable with telling me things, whether it be what they did for the day, or to ask a question, or just a listening ear. That's often important. But today in this court, it's unfortunate that I have to stand here and pronounce the differences that have been created between my ex-wife and I in her attempt to sever that bond. I want to make sure that this no longer basically has the ability to happen, and my boys are able to grow up in a household where they're appreciated, motivated, and that they don't become robots, behind a screen and in a technology world, because that's so easy to have happen. I want them to have direction that they need, and a foundation that comes from simply having a place of their own to learn and grow, to form good habits. But I've learned that my boys have been deprived of these things and these essentials in the other household, whether it be a space of their own, or simply have more than just their electronics available to them. My oldest one, he had an issue where I had to discipline him, and I was going to do so by way of the phone, because he wasn't using the phone for what was important and a phone is needed for. But I found myself combated with the fact that his response was, "That's fine, I understand your reason, but you're taking away the only thing I have available to me when at my mom's for me to do." And so I had to find a different way to go about that, which wasn't a problem, but at the same time, it brought more concerns. During these ages, as parents, we have to remember things that will change from when they were kids, such as situations that may surround them, and peers and peer pressure, having to make decisions even related to those new and different situations. Or perhaps it entails privileges that come with age, such as the ability to drive, where as a parent, you're left only to fall back on the trust that we've established and the good habits we've helped develop. But when this is all jeopardized by one parent or a parental role, it doesn't embody those habits themselves, and it allows them to spend what time they have with their kids on the sidelines, maybe not putting in the effort or the right focus in order to provide the best possible situation for the children. And without that effort, you often lack the ability or desire to even have the energy or focus, or be able to pull that away from yourself. And in my case, put towards these two amazing boys. I fully believe that balance is important and not easy to maintain, as the variables that I see being very difficult and challenging for these kids are endless. And it happens because every kid's different. But it doesn't mean that we shouldn't manage and balance the time that we spend and appropriate that time in ways that benefits the kids. Otherwise, it does them no justice. With all that being said, the biggest blow was not the unethical and unprofessional, hurtful, and malicious things that have been said and continue to be said about my character, and that of my soon-to-be fiance, who in fact shares my goals and love and effort for these children and has done nothing but be a positive role model for them. It's hard to understand why my ex-wife, out of all the relationships I've had, seems to have trouble with this one when the kids only speak so highly of their situation here. I understand that none of us are perfect. I'm not here to say that I can create a perfect world for them and I'm without fault. I own those faults that I have. I'm not perfect, and the reality is that this is a divorce. And the most difficult decision I had to make with this divorce was one where I had to decide, due to infidelity, whether I wanted to continue. And I decided to give it that second go. So I taught my kids a lesson that it was important when you have something like a family that you give it your all. But when that went sideways, I had to ultimately end it, which is basically what brought us here today. My hope is that the court can see with the testimony and the evidence that I have that truly make a decision based on the best interests of the children. You know, that's all I can ask for, to see the environments that they have surrounding them at each parental household and what's fostered within that household and what it will do for them as they grow into these very important ages. You know, focuses like school need maintained for the 13-year-old. And if it's troublesome somewhere, that needs to be identified and called out. And it's not my intention to put blame to the other party, but it's my intention and it's my duty as a parent, I think, to make sure I give these kids a fighting chance to have what they need in order to thrive and become young adults. Remember, these are two boys, and those two boys need a father figure and need, if anything, just a figure in its own that's strong and has these beliefs and can follow that structure and create that pattern and those habits that allow them to make good decisions and prosper in life and stay motivated to do things that will make them better humans, basically. So with that being said, Your Honor, I do close my opening statement and just wish that the court keeps that in mind as we go forward with what is shown as evidence.
Okay, well, Mr. Wolf, so this is a modification.
Oh, I apologize. Yes, I should state what I'm looking for.
Well, two things.
Yes,
For a
ma'am.
modification, you have to be able to establish there has been a substantial and material change since the last orders put in place. I have not heard what that is, nor have I heard what your requested relief is.
Sure. I apologize for that. I had that statement in my testimony. I was using that for that, not knowing that should be a part of this. I didn't want to have the length of the opening statement be too long, but my desire is that I maintain full custody of the children and that I'm able to make the decisions for the children going forward. Because of the concerns I've had with how the co-parenting aspect has been, the communication between myself and my ex-wife, and the following of our decree, or how she has followed our decree. Things that are a concern are the fact that she's gone beyond what doctors have given their advice on or their diagnosis and created a self-diagnosis essentially and followed those reasons for what she wanted to do versus listening to doctors and so on, and including me for that matter in that whole process. Her evictions, she's had 2 evictions over 2 years. She's had her cars repossessed. It is clear and apparent that just from her own attorney and witness statements and so on, there's instability. There's trouble with finances and financial hardships. All these are not something I'm condemning her for. However, it impacts my children. My children do not have a place of their own to call their own space. My youngest son sleeps on a couch in an office that's open and actually has not slept in his own room in over 3 years. And this carried from the last apartment over to this place. So their only available items within that household are electronics, and all the other items that they have are in storage. So the only thing brought to and from the households is literally 2 bags, one of clothes and the other of their electronics. And the battle that I had with my oldest was the mere fact that he was clear when he said, I don't have anything else at the house to entertain me or to be an outlet for him, a way for him to reach out or just zone or zen, whatever it may be. And my concern is that the attendance with the school, my oldest son, who was straight A's, went to failing school as of his 10th grade. As I transitioned him to a new school that he requested to be at to flourish in baseball, that became evident by the counselor. And we had to make up classes in order for him to get to where he needed to be just to graduate. And that was all due to attendance concerns and lack of homework and being a part of that life and not allowing me to have access. And I know that it's up to myself as a father to get that access, but with the schools the way they are, they only allow one portal with one sign-in. And she kept saying, I'll get you that information. I'm having trouble. I'm calling this and emailing this. I never got it. the truant. He's had so many attendance issues that he's gotten truancy letters. And it's only during the time that they're with her. I mean, I have a calendar that outlines our weeks, and the amount of excessive absenteeism and the reasons behind that don't add up. It's not, there's many reasons why they're invalid. For instance, a funeral that they knew nothing about or knew the person of, but because she had to be in a certain place, she decided to have him leave early from school, still at a borderline with his grades, just so she didn't have to have him not have a way home, when she could easily reach out to me, who I live 2 miles from his school, not even, and I have the ability to pick him up at any time. My kids were forced to stay after school for almost an hour or more at a time for a period of time, in which she asked friends of ours from the baseball family if they could pick the kids up, probably because hopefully she felt the same way I did, that time could be spent much better doing homework, following up the studies, relaxing, just whatever it may be, instead of being at school and forced to sit there or be in an extracurricular program that really embodied just running around and playing with friends for my youngest. So, but she never reached out to me for those things. And it's merely because she wanted to ensue a power. This whole thing has been about a power struggle. She's used their schedules and changing their life around from the last 9 years of a balanced schedule to that of a schedule that we had for 1 year while she worked at a job, the first year of divorce, which the decree was stated, but we mutually agreed, and it benefited the children to go to a week on, week off, where the week wasn't split in half, and we can be consistent with the homework that was due from the start to the end of the week. And this allowed the kids to flourish. Their grades didn't suffer. They did well. But this transition, these evictions, the fact that their bedroom furniture was repossessed and that they don't have their own space. And even when she had a separate room at the last apartment, which was supposed to be a shared space, she didn't manage that shared space. And because of that, my son could not sleep because my older one was left to be able to game till 10, 11 o'clock, 12 o'clock at night, or be on the phone with friends. And that disrupted my youngest one's ability to sleep. And at that time, he was especially concerned with school. So he has since then slept in the living room.
Mr. Wolf, this has gone well beyond any opening statement. So I'm going to need to cut you off and save it for testimony at this point in time.
I understand, Your Honor.
Ms. Hobron, you may proceed.
Thank you, Your Honor. This modification, the petitioner filed first about 15 months ago. We filed an answer and counter petition, but not before a TRO was filed. I had about an hour notice before I attended that TRO hearing in which it was denied. We did temporary orders in which we were ordered by the court to continue on the orders in the original divorce decree. So the evolution of this case, initially I came involved with this case on a limited scope basis as needed, just to help the respondent with very discrete tasks, some settlement negotiation, attending that TRO, attending temporary orders. After the fall, my client was completely exhausted of funds, but I can say personally that she is a wonderful, magnanimous person who I ended up becoming personal friends with. During the course of the year that we've been waiting on this hearing, she's been working multiple jobs and unfortunately was not able to get ahead financially in order to retain other counsel. I'm currently going through disability proceedings, as I said this morning. It's very difficult for me, stamina-wise, to go a full day. But our options here were for Ms. Wolf to assist me when I have fatigue issues so that she had some access to justice, or for her to have no representation whatsoever here. I think as you can kind of gather from the opening statement, Mr. Wolf has a very detailed view of how he sees things in the world. However, for our part, we're coming with witnesses and physical evidence and testimony of 2 decades worth of building levels of coercive control, financial abuse, verbal and emotional abuse, penalizing the children by failing to feed them because he's unhappy with their mother. We're going to show evidence that my client is always been responsible for enrolling the children in school, for their medical needs, for taking them to doctor's visits. We're going to show evidence that my client is currently in possession of the children Monday through Thursday. So if there is a missed school day, of course, it's most likely to happen on her day, but we will show evidence that these healthy children are leaving her possession and coming back ill. And so the reason so much illness is being handled during her possession period is a number of factors that we will definitely explore during the course of the evidence in order to substantiate that point. What we're asking for, Your Honor, has changed over the course of time. Initially, the counterpetition, in response to what was petitioned for against the respondent, there was an attempt to stick by some sort of week-by-week schedule, try and continue to maintain joint managing conservators, efforts to mediate, that kind of thing. It's simply not working. It's not going to work. And ordering these parties to continue to be joint managing conservators is endangering the children. On that, I think Mr. and Ms. Wolf both agree that it is time that changes. We are asking, however, that Ms. Wolf be named as sole managing conservator, that a standard possession schedule be put in, that standard child support be put in, that standard medical support be put in. We will demonstrate the financial ability of my client and the reasons for her having financial struggles, which is in large part for being solely responsible for many of the bills over the years, medical bills for the children, without receiving any sort of support, which is what the original order called for, was splitting medical support, and otherwise they had 50-50 custody. So no child support was ordered. My client, the respondent, the mother, was ordered to be the original recipient of child support if it was ordered. Their initial decree was done between them on a form without any advice of counsel. And the testimony that we're going to present is basically, it has been an unacceptable document for the way these two have operated pretty much since the first year. They were able to collaborate initially on a lot of things, on what the schedule should be, but that has deteriorated substantially in the past 4 or 5 years. So we're asking the court to just give the people who are witnesses the opportunity to speak to their knowledge as to who they believe should be primary, what is in the best interest of the children, and that some relief can be granted here.
Okay, well, are you calling a child custody evaluator? Or are these just lay witnesses?
These are lay witnesses of just people testifying to what they've seen as far as the parents handling different responsibilities. They're also testifying to the drug use by Mr. Wolf. They're testifying to abusive behavior. There's their first person testimony, but we do not have an expert for this. It's going to be in the court's discretion what if they feel the evidence is persuasive one way or the other.
Okay, well, they can testify about what they know and what they've seen and heard, but child custody evaluators typically are the only ones who recommend to the court access and possession or primary. So I just want to make sure that's clear for the record.
Yes, Your Honor. None of them are testifying as experts. They do have, from their experiences, their personal opinion on the well-being and safety of the children, because they all know the children, about what would happen for if either side was granted primary possession and the other one was only on visitation. I will limit my line of questioning in order to be very narrow and focused on that without calling for speculation.
All right, Mr. Wolf, that takes us through openings. You may call your first witness.
Okay, so I'm not necessarily going to call a first witness. I want to speak to the witnesses that they have, who actually have spent no time with me, who haven't been a part of my life at all within the last several years. By several, I mean more than 4 or 5 years, 6 years for that matter. And when they were a part of my life,
Objection, Your Honor, relevance. I don't understand why the witnesses would have to be interacting with Mr. Wolf directly for them to have interacted with the children and testify to my client's ability.
I didn't hear a legal. Was the legal objection relevance?
It's relevance. I don't understand.
Overruled.
Okay.
All
Thank
right.
you.
So, Mr. Wolf, just to clarify for the record, it seems as if you were calling yourself as your first witness in your case.
Yes, ma'am.
Okay. You may testify in the narrative form since you are representing yourself. So I need you to focus your testimony just before you start. The divorce was 12, however many years ago. I'm not interested in the divorce in any way, shape, or form. I'm interested in the modification motion and what evidence supports whatever it is you're asking the court to do, which I don't think you really told me in your opening. So now might be a good time to tell me what you're asking for and why.
Sure. Well, I am also asking for not joint, but sole custody of the children. More importantly, just the fact to be a sole conservator and make the decisions for the children. The way the decisions have been made have been in bad faith, and it's without proper research and time spent, including both households, to understand the overall picture of the children's situation versus just a one-sided thought or approach or statement. The standard possession order is also something I'm looking for. I'm not seeking child support, and in fact, I will even put a clause within that standard, visitation schedule that if the kids want to see their mom, they are welcome to, as long as things are, accounted for beforehand and that it's able to be done. And vice versa, if the mom wants to see the kids. So my thing is not to take the kids away. My problems are the standard of living. I can introduce evidence such as P12, which in the TRO hearing, it states that, opening counsel, let me just say this. Opening counsel mentioned some things that are of concern. Some of the things such as abuse and other things that they are insinuating, unless they were here to witness, it's hearsay. It's just what those other people have said. I've not known these people, so I want to have that kind of rectified out. But furthermore, I want to testify to what I can prove. And that's the living conditions that they currently live in and were forced to live in, despite the order made by the judge during the TRO hearing. I think the video was taken, no. When she lived with Kevin and Lauren, it was required by the court that the kids had their own space, and that the kids had their own beds. There was testimony provided by the other party that stated that I was abusive and that I was arrested and for assault with a deadly weapon on a homeless person downtown, and that I used her vehicle for things that I did not use it for, and that the kids were scared of me, and none of that was true. And with that being said, and the fact that we couldn't agree, which is why the actual judge instilled that old schedule of the decree.
All right, Mr. Wolf, I need to interrupt you because what happened at the prior hearing is not what I am deciding today. And I want to make sure you're aware the Texas Family Code has a presumption that the parties should be named as joint managing conservators. Unless certain factors can be met, that is a presumption that the law has. So you need to focus on trying to convince the court that those factors are in place so that you should be named sole managing conservator, which I take to be your request.
Okay, well, I can speak to the fact that she does not have a place where the kids have a space of their own. I can speak to the fact and show evidence to the fact that.
Well, what do you mean by that?
Well, they do not have a room in which they have of their own. The rooms, she rents 2 rooms out of a house. And within those 2 rooms, she has one that she stays in, that she spends the majority of her time when with the kids in. And then the boys are have a room that they were supposed to share, but the managing of that shared space has been absent, and therefore there's no shared space. My youngest son has basically been occupying an office and sleeping on a couch this entire time while at this residence. When at Kevin and Lori's, the requirement that she had beds for them, proper beds, they were sharing a space with her on her bed, and she bought them cots, which I have as evidence, versus a bed. When she mentioned that she clearly had beds for them, she's going to illustrate this fictitious thought of how they live when their prior apartments were infested with roaches. And one of the witnesses that they're bringing today has and will testify to that as long as they are under oath and telling the truth. And we're personally a part of those experiences with me. They're sick. She's mentioning that they come home sick from my care. They do not. I'm prepared to show the attendance shows that these are often her own diagnosis of things that she's feeling they need to be at home or sent to the doctors for. Had nothing to do with the time with me. I have pictures of where they stayed and things like that. The mismanaging of, making a child feel like they need to be sent to therapy because they're attacking the other sibling when they are left to be in a room together with no other device but electronics, and she is absent 90% of the day. And I have testimony from my son, which states the amount of time that she takes to spend with him out of a given day. So those are all things I want to present to you. I guess the best way to do that is just to kind of get started. So P11 evidence will show pictures of her time while with Kevin and Lori, which is after the TRO hearing, so it's most recent besides this new residence. They showed
Okay,
how
you're going to need to share your screen if you want to show me a piece of evidence and offer it into the record.
Okay, I didn't know how it works since submitted evidence, if I have to pull it up on my end or
Nothing's been admitted, so if you want to offer an exhibit, you have to display it on your screen and then you have to offer it, and we'll see if there's an objection or not.
okay. Well, just P12. Forgive me here. I'm just trying to pull this up. I'm trying to figure out how to show it.
There's a green button at the bottom of the Zoom screen that says share screen.
Wonderful. Thank you. I might have my self on that. Share content. Gotcha.
Okay, I don't know what that is, Mr. Wolf, but are you attempting to record this Zoom meeting? Because you do not have permission to do that.
I don't know why I'm clicking all kinds of buttons. I apologize for that entirely. I'm trying to Zoom meeting. Okay. I'm sorry. My laptop was not working, and I'm using a device that I'm a little unfamiliar with, so I apologize. As you can see, I'm having a lot of trouble here. P12 is showing basically the way that she interpreted a bed.
Okay, we can't see anything, Mr. Wolf.
Oh.
You're not sharing the screen.
I
And
apologize. I did select that. Share content.
may I make an objection on foundation at this point, just so we can establish how to admit this evidence? It does not seem like Mr. Wolf is going to know how to set up a foundation for how to get this admitted.
Well, I
Your
think
Honor-
he's got to attempt to show it first, and he hasn't gotten there, so I think it's premature.
Your Honor, I asked that if the motion of continuance was received, that I had sent over and the reasons for it. during the last illness I had that prevented me from being here, I'm sorry to sidetrack, I do apologize, but the short span between that and the scheduled hearing, with all that had taken place, which is also provided in that motion and continuance, has not allowed me to obtain counsel, because they've all said that with allegations and things going on of that nature, I need more time to prepare. And it hurts me because I feel so prepared mentally, but things like this, I'm just not familiar with, and I'm fighting for what's best for my kids. And I know that you want this represented a special way, and I want that too, but I don't feel like I'm doing my kids justice or myself having to represent myself. These are concerns I brought up, and I tried to file that motion so you would see that. I was just wondering if you had the time to see that, Your Honor, and take that into consideration.
All right, Mr. Wolf. So I did see that you sent a motion for continuance, and I guess you filed it just a few days ago.
And there are reasons for that are outlined in what I included with that motion, if you would.
Okay, I understand that, but I just need to say that motion, although it was filed here recently, that is not set for a hearing today. In addition to that, the prior judge who heard your prior continuance on the 1st of November made it very, very clear that no further continuances would be entertained. So that's the end of that discussion. So on the bottom of the Zoom screen is a green button.
See that?
Says share screen. That's how you show the court any exhibit that you want to display before you attempt to offer it.
So hopefully this works this time. It's saying that the screen is broadcasting under the Zoom application. The only other option is to stop broadcasting, though the picture is not clear at this time. So I don't know if it's the transition of the material coming to the Zoom meeting, or...
We are not seeing any document. We're literally seeing something that says screen broadcast, which I have never seen before. I don't think you're clicking the right button.
Stop broadcast. Okay.
Share content is not the button. It's a button that says share screen. And I am concerned because it does appear like you are recording or broadcasting something. I'm
not familiar with this. I thought that was the share content. It's the only reason why I selected that. I promise I'm not trying to share any content whatsoever or anything like that. Now I don't know how to stop this share content. Your Honor, can I ask for a moment to kind of work out for me and take a small quick... I don't know how to stop the share content. I can only...
Well, it's stopped. It's not... We're not seeing that any longer.
Can I ask for a recess or anything like that, just so I can get this together, so I don't delay the court and waste anybody's time? It's not my intention. I apologize. I know it's just abruptly after starting, but I don't think it's going to do me any good or the court to feel like I'm doing something that I'm trying to understand and get better control of. Okay.
Have you looked at the bottom of the Zoom screen?
Yeah, I honestly don't have anything down below. I have the options up front, and I'm even minimizing that Zoom screen because I had it, enlarged. I see my picture on the bottom right, and I have the only options up at the top, which is mute, stop video, share content, and so on.
Okay, you're not seeing a button for share screen.
No, I really am not. And again, I'm unfamiliar with this device. I apologize.
Okay. We can give you a few minutes to troubleshoot this, but Mr. Wolf, this modification is longer than a year old. So, and as I stated, the prior judge has already ruled no further continuances will be granted. So we're going to need to proceed. You've had 15 months to
correct, but
get ready for this hearing. And, the parties requested a remote hearing. So if you weren't going to be able to handle the remote technology, you could have requested an in-person hearing, but it's too late for that at this point in time. So we'll give you until 2:50 to work on it. So take a few minutes and see what you can do in that time.
Thank you.
We'll all stay logged on. You can mute or turn off your video in the meantime. All right, I'm just checking back in to see, Mr. Wolf, have you figured out the tech issue with the Zoom sharing screen?
I'm sorry, the only options I still continue to see are the share content button, which I'm selecting. I'm going to try it once again. Screen. In the screen broadcast. It's the same screen broadcast. And it's the same.
Yeah, that's not how you share a document on Zoom. Okay, well, if you're not going to be able to share the document, then you're going to need to just tell me what you want to tell me.
Basically,
Mr. Wolf, you need to turn your video back on. We're in court. So
sorry. Okay, I apologize. There we go. Okay, the living conditions that they live in have been unsanitary. And I know I'm going to probably get a million objections because I can't get my evidence to show these things that I want to show, that will show the proof. The time that's spent, I have video recordings of my son that mentions the time that's spent with him in his studies and how they aren't given any time to or any place to do their studies. All the things I mentioned, the living conditions, and none of it fosters or has fostered their ability to grow or do what they need to do in order to maintain, proper schooling. I wanted to see what it would take even to bring my kids into being interviewed by yourself, so that way maybe they could project a better light, because they are of age to speak on their behalf. And I'm not an attorney, and I'm just sorry. I tried to get representation. It was a mere series of just crazy events that they've imposed on me during that time that caused no attorney to want to work with me or have the ability to do that. They all mentioned that they're happy to be my attorney, but they need more time. The other opposing counsel, in the documentation I provided with the continuance, sent information to my fiance's dean and made malicious allegations, all of which they said in order to combat that, we can't have just a few days. It's just not going to work like that. We need more time. And though they're willing to, I'm unable to have counsel, which puts me at a disadvantage. I didn't want to come in like this.
Your Honor, hearsay and relevance, mainly hearsay, is to the points of what other attorneys have told him. We have nothing to substantiate any of that. And as far as relevance, I believe he's referring to the midnight motion for continuance from Friday, which we've already resolved.
I'm actually referring to the malicious responses from you and the constant accusations that considered abuse and several other false things, including what on my now soon to be future fiance, and sending an email to her dean of her law school so that she can be thrown out unless I sweep the motion under the rug, as you stated in that letter. And Your Honor, these things that she put in this letter are grounds for disbarment. And that's why it was that time that I actually was able to initiate it. It's not meant to be a last minute thing or to waste the court's time, but it literally put me in a predicament where no lawyer could do something or represent me within that short amount of time. And I have responses from attorneys that mention that, that I reached out to. I mean, I was searching outside of the norm just to try to acquire representation, even at a limited scope.
Okay, Mr. Wolf, your attorney withdrew in August 2022.
Yes, ma'am. Only because.
Well, it doesn't matter why.
Well,
the attorney withdrew in August of 2022. So the argument that you have not had time to obtain an attorney is on its face absurd. And the continuance has already been ruled upon. We need to,
Right.
you told me the living conditions are unsanitary. What are the details that support? That's an allegation. You've given me
Sure.
no facts to support it.
Sure.
I need facts, I need information, I need evidence.
So for 3 years, and I can, talk to their witness and prove this if they're telling the truth, that for 3 years I was responsible for bringing the kids to school and had to go and arrive at her place in order to make sure the kids were ready to do so. During that time, her apartment was roach infested, and by infestation, it was more than that sense. My kids would grab their cereal to make a bowl of cereal, and roaches would be coming out of it. There was mold and dirty dishes left for weeks on end. It took one of the witnesses that they're bringing and I a full 8 hours just to clean the boys' room, and the rest of the scope of the apartment was just cluttered to the point of a fire hazard. Instead of going to the apartment and asking for help, because of the way the condition of her apartment, she was worried that she was going to get evicted. So she was creating her own remedy with bombs and such from Home Depot and not giving enough time for those bombs and that chemical to clear before moving back in and inhabiting that space again, because she had nowhere else to go. And my kids can testify to it. My kids call roaches their friends, and I have video and audio mentioning that. These are conditions that affected their health, not what's here. The health conditions are also my oldest son. She moved him to a GI specialist because of his constant trouble with stomach issues, but yet she fails to see or listen to the doctor that he's had his entire life, that has stated over and over, year after year, that his eating habits and what he's eating, being primarily fast food when with her, has caused these issues. And so she disregarded that and said, well, I still need to go and have a GI referral, which I've already started, and have him looked at, which he was deemed fine by the GI, no issues. But even with that being said, she has not corrected those habits of fast food all the time and malnutrition. I have the coach of the baseball team that can testify and has an audio that Braden and Connor went a week with just a plate, spaghetti as a means of meal. And he ended up passing out on the baseball field because of this. And he knows this because of my son and his relationship. They've known each other most of his life, and he's his confidant outside of myself. Those are huge concerns. And a lot of the reasons why she had them out was not, it was her saying that he had a headache, or that he needed to rest before going to the dentist appointment, or that he didn't feel good, but she did all the checks and he was COVID free all the time, and no nausea and no outlying factors, but that he felt fatigued. And so she kept him home. And that's in her own words, in her own writing to the school. It's just really troublesome trying to go through this and not have the proper steps in order to do so. But those are reasons that I'm trying to bring up, and evidence I have that I would love to share. And I don't know if tomorrow, I'm going to make sure I have a different device come tomorrow, that's for sure, so that I can share this testimony and this information with the court and not waste the court's time. Right? I mean, I've worked so hard to provide a stable home, which is paid in full, has been since I bought it, that has their own space, their own rooms, that spawns creativity. I have plenty of things that we do throughout the day, and all the time is invested in them when I have them. And when I don't have them, I spend my time. However, with her, she takes the time that she has the kids and still utilizes that for her time and going to concerts that are all day events and night events. A concert in which I was actually at for the night portion, but before going to, I got a call from my son saying, Dad, is there any way you could stop by and get some food, because Mom didn't leave us with anything and we're hungry. How long has she been gone? All day. And this was a country concert that we both were at. And I mean, these are things that are issues that are, the school records. It shows that, of course, she had to take him to the doctors because it all fell during her time. I get that. But those times that she had, we had the biggest attendance concerns, they were when we were doing a week on, week off. We didn't just start that new schedule until the TRO hearing. And even though that was 2 years ago, the attendance issue spawned way before that. It started with his first year in high school. And it was such a concern there that we had hoped by moving him, it would create new habits. And even he said, Dad, I know that sometimes I'm maybe not fully sick, but hey, I mean, And it's a teenager to do so. If he's going to be able to get away with it, he does. He was driven to school and said, man, my legs really hurt. In which she literally had him there, a foot out of the car, and said, you know what, why don't you just get back in, we'll go home. And he went home instead of being at school. You know, I make sure that my focus is toward the kids and we're doing the right things. We built a business for the kids. We make sure that their time is spent with friends. They cannot have friends at the residence that they're at. This impedes their social interactions. She lives at a place where it contains also 2 Alzheimer's, folks, and not saying anything about that, but the kids can't be loud. The kids in the testimony from the psychologist that she took them to, which for that matter, my thought on the choices and the reason why me having concerns with that is she took them to a drug and rehab specialist that focuses on young adults and transitioning into its Austin Recovery Services. That's who she chose to have my child speak to, with concerns that he had a learning disability and that he was not getting along with his brother and instigating fights. But yet he was left in a room with just his brother and no one for the period of the majority of the day outside of an hour and a half to 2 hours. And that was a discussion that we have on audio record that talks about, why do you feel like you were put to therapy? Were you told ahead of time? No, I wasn't. Were you forced? I wasn't forced, but I was told that I can't do anything. I have to do this. And even the testimony from the psychologist says they only felt comfortable with you. And the concern that he had was that the kids are not able to have the creative and ability or foster things with friends and other outlets that would prevent just being left in a room with your brother. I had a brother the same age difference. I know what that's like. You're going to drive each other's crazy. But instead, he came out feeling like he was being attacked and the only one who was doing something wrong, when those behaviors do not happen here. I have countless evidence of him and his brother. They work well here. They play well together. We do things as a family. They're included. We have dinners as a family. We have discussions. That doesn't change. It never has. But that doesn't go on at her residence. She spends majority of time in her room, either on her phone or some other device, or talking with her boyfriend, and they're left to basically be on electronics all day. They brag about being on for 13 hours of a day and joke about it, but it's not funny. I mean, I want to remain lighthearted with them about it. I try to say that it's probably one of the best things that we can do with our time. But what they're doing with their time is not growing them. It's not, they don't have any resources or anything there at the place because she keeps moving from place to place. Everything's in storage. And during this time that she was left without or in this struggle, she's buying things like ice cream makers and popcorn machines from people on Marketplace and bragging about it to the coach as a means for being late to a baseball game when asked. And it's on a recording. And they can testify that. I'm those are things that I have concerns with. It's not the fact that I'm trying to pull weight with them seeing their mom or trying to pull power struggle, which this has been, but it has never been about the kids, because in all the decisions that she's made, bringing the police in, saying that we're needing, visitation with supervision and everything, that's never been the case. The kids have always been happy and they're being put through this turmoil. The fact of the matter is, during the TRO hearing, we had appointments for exchanges in which she never showed up. The kids literally went with me at every attempt of exchange that they were well aware of where we needed to be, and she didn't show. Further, she never even called the kids and explained maybe why she didn't show. She had plenty of avenues, because we weren't on the band app at the time, to reach out to us and me to ask, where are you? If it was me and my kids and I was to do exchange, even if I didn't know or I was unsure or things were, just convoluted to where I didn't understand what was going on, I'd be texting, where are you? Where are my kids? She trusted me to take them when she lost everything in her home in the matter of a day or two with no notice. Why did she trust me if she's stating all this is the case? Why would you trust me to take them on full time? Why would you allow my oldest son to make a decision, even at underage, to stay with me and grant that decision to him? It doesn't make sense. What they're saying, all these allegations, they're all false. They have no merit. There's nothing that they could do to prove this. And it's troublesome because it's dragging my kids through this, and they're sitting there waiting for their mom and going, finally, the fourth time we tried to do an exchange, like, Dad, I don't want to be here. Why can't we just go home? Why do we have to be here? She's not going to show. Followed with no contact to them. And then I was demanded to give her extra time for those missed encounters. A big statement from her was that I took the kids away from her without her consent for a California trip and impeded her time. I did not. She was well aware of the California trip well in advance. It was for my son's 16th birthday, which I did a great thing and brought him to a baseball field for the home run derby that he loves and is passionate about. And I gave her the
Sir, I need you to slow down a little bit, please.
Oh, I apologize. I apologize. But I gave her the week prior, which was my week, so that she can have the kids and she didn't feel like she was losing time. And then on what would have been her weekend that she said I left on, I didn't leave till Sunday after the time the normal exchange would have happened anyway. So I didn't impede her time. But I've been spending so much time focusing on having to, debunk these allegations and all what they're saying. It's exhausting. And I understand without the proper documentation, you're only taking my testimony and I'm sworn in and I'm absolutely telling the truth 100%. And if my statements are not enough, I had hoped that my evidence was enough. And if not, the reason why there was such a delay between back then and I had the time was her counsel fell off, stopped talking to us after we put a Rule 11 in place that required that a custody evaluator happen. Now, mediation was an option to be discarded or, ruled over by a given party. I understand that. I offered to pay for the entire custody evaluation cost. They stopped responding to my attorney. I have an email from my attorney, which accounts for the fact that they stopped communicating with him after multiple attempts by him and us to reach out. Haley, the counsel, did not respond. And we were left in that quandary of what do we do? That's the only reason why we mutually agreed to release his, my counsel, because nothing was moving forward and I was not being given any options to move forward myself. I would have happily paid for a custody evaluator. That's a requirement in Rule 11. That's why I put that in place. I asked for that. I wanted a third party to be able to see the homes and witness what goes on and have a chance to speak to those children who I'm fighting all this for and who have come to me as a confidant and who are only comfortable with coming to me, and even my fiance for that matter, because that's what we've created. And here I am today trying to fight this fight, and I'm just doing them such an injustice. And the weight that puts on me is just unbelievable, but I'm here willing to fight the fight because it's what's right. It's the truth. And you're always here. The truth will set you free. Believe in God, believe in doing the right thing, and it will prevail. It will show its way. But technology has killed me. And the ability to have proper counsel, even to obtain my most recent, my past counsel, would be happy to. He even told me I'll be happy to jump back on. But everything needs time because of all these root allegations and things that she's created that we're going to have to fight before we're even able to prove our points. And the history of her allegations have already been received and shown as false. I don't have an arrest record. I hold licenses in every state where that would be, I would lose everything if I did that. My jobs, I've had great jobs. I've maintained stability here. They're given healthy foods here. And things have been changed all to better and accommodate for what the doctors mentioned to keep them from illnesses. But because I'm not at the other place, it always falls in that. And she always tries to put blame, even in the app and messages, that he said he was feeling sick before this, but he was not, and he never did. There's times where she's instigated things such as, well, I'm sure you don't want your father at this doctor's appointment when he had to go for his shoulder for baseball. And basically it was complete insinuating to him that when he never said or mentioned anything like that. And I can keep him out of the doctor's room if you need me to, if that helps. He goes, I don't care if he comes anymore. I don't care. And that's been my kid's common response as we have these battles, I guess, so to speak, about what's best for them. Because I just don't know. I would like her to be able to prove to me what we have done in our residence to make her feel like she could not have come in the days that she did with a small amount of notice and asked me to take on these kids full time, and why she felt comfortable to do that, but yet imposes things like supervised visits and concerns with drug abuse and all this stuff that I can't do. I'm tested all the time. my history and work ethic would not, and my upbringing would not allow it. And
All right,
now
Mr.
people
Wolf, you've used about an hour of the time
apologize.
that you have allotted for this hearing. I know you'll want to save some time so that you can cross-examine the witnesses that Ms. Wolf's attorney will be calling.
Yes, ma'am. Thank you. I'm sorry.
Okay, do you pass yourself as a witness?
Yes, I do, Your Honor.
Okay, Ms. Hobron, do you have any questions for Mr. Wolf?
Yes, Your Honor.
Go ahead.
All right. For the record, can you please state and spell the name of your paramour, Sasha McClellan?
Sasha McClellan. That's Sasha. Last name is spelled Maclennan.
And when you are discussing your fiance, you are talking about Sasha, correct?
That is correct.
Does Sasha reside with you?
Yes, she does.
Is Sasha subject to any sort of court proceedings that would prohibit her from being in possession of children or anything of that nature that should be of concern?
First of all, I can answer that. However, I would like to speak to that. I can see relevance, but that shouldn't be
Objection,
relevant.
Your Honor, non-responsive.
Sustain. Answer the question.
No, she does not have anything restricting any of her abilities to do anything whatsoever. She is highly educated and in law school, so there's a lot of checks that go in with going to Baylor University. As you know, Your Honor, being yourself.
Thank you. Thank you. That answers my question. Moving
Great.
forward, so that we can try and get to the meat of this, because Mr. Wolf, you didn't have the structure of questioning because you're representing yourself. So I'm hoping this is an opportunity for you with some structure and being questioned that you can answer a few things for us.
On answering, I'm absolutely being
Wonderful. Okay. So you say that the children come to you and your fiance in confidence to discuss these things. Do you mean that you are disclosing facts about this litigation to the children?
absolutely not. They come to me with statements about their day and their time while at their mom's, because I'm interested in what did you get a chance to do this week? Those are questions, if anything, that are asked. Otherwise,
I'm so sorry. Pause. I'm so sorry, Your Honor. Today is fire inspection, the annual fire inspection in my apartment. I just have to let them in. This is may I do that real quick?
Yes.
Great. Hi, sorry. I'm here. I'll leave it unlocked. Top 10 most embarrassing things that have ever happened to me. I apologize for that. And I apologize for disrupting the flow. Mr. Wolf, have you had an opportunity to review respondents' exhibits that were uploaded to Box for the first hearing and for today?
Yes.
So you're aware of their contents?
Not of the contents, just a list of what they were bringing, not of the content.
Okay, so you did not review the evidence that was uploaded to be brought against you?
No.
Okay. Have you requested a copy of the children's medical records from their primary care physician?
I have access to that. I have access to those records.
Have you requested the documents so that you actually have the medical records for the children?
Yes.
Okay. So you have their full medical records and can refer to those?
Yes.
Okay. And you're aware those records do say that Braden has a stomach issue?
Yes. I didn't refute that.
So when you say that it's just because of the way he eats or that it's how he's eating at the respondent's house. You're not denying he has a stomach issue. You're just saying it would be curable if he just changes his diet. Is that correct?
I'm saying that the doctor diagnosis was that his stomach issues are related to his eating habits. And that's what was said in the
Gotcha.
request to the GI.
So you
Okay.
have access.
I need to interrupt because y'all are doing a terrible job of question and answer. I need one person talking at a time. Ms. Hobron asks a question, then Mr. Wolf answers it. No talking over each other. The record's going to be terrible if you continue to do that. Go ahead.
All right. Do you happen to have, you said that you had the medical records for the children. Do you happen to have the medical record that shows that Braden, it's an eating disorder versus a stomach disorder?
No, I don't have a record that states specifically there was an eating disorder.
Moving forward with Connor, you did briefly mention, I believe, the psychotherapy. Have you had an opportunity to look at the exhibits that respondent has submitted that includes just the notes from Connor's psychotherapist?
Yes, and I received those notes as well directly from the therapist.
And do you disagree with the therapist's presentation in those notes that you were combative and got into a thing with him?
The beginning of our conversation was direct questioning to him. He felt as if I was an attorney. Once we cleared that matter up, there was no problems, and we worked cohesively together to understand what took place with my son while he was—
Objection, Your Honor, not responsive. I'm asking yes or no, and then if I need more information from you. Yes, you disagree with his notes in that. That you two got in an altercation when you called his office.
Yes.
Okay. You have read those notes that say that Connor is having attachment issues with his older brother entering adulthood and getting ready to leave the house, but you do not agree that that is a reason to go to psychotherapy for a child who's 13. Is that correct?
No.
I think I phrased this terribly. So you do not think, you do not think that having relationship difficulties with your sibling is sufficient cause for a child to go to psychotherapy. Is that correct? Yes or no?
Yes, if proven. Yes.
Okay. Do you believe that the kind of tension that's happening between you and Miss Wolf is sufficient reason for the children to go to psychotherapy?
Sure, absolutely.
Is that why you had no problem with Braden going to psychotherapy after the divorce?
I was not made aware of that until after the fact. So there's nothing I could do about it. I could choose to be okay with it or not. It happened, and I don't have a problem with therapy, if that's your question. I believe in therapy. I think it's a good thing.
How long was Braden in therapy?
Like I said, I wasn't even given that information. So as far as specifics, how many meetings, who he met with, she never provided. So I don't know.
Okay, let's do some more recent basic things.
Sure.
You are aware that she has not lived in the house that you've been talking about that was subject to the TRO hearing, the temporary orders hearing, that she hasn't lived there in over a year and is in another household. Is that correct?
Correct.
Do you have any complaints about her current household?
Yes.
Can you elaborate?
My youngest does not have a space of his own. The space that should have been shared is not managed to where neither of them have things that other than electronics to do, nor do they have anyone to spend time with.
You are aware that both boys now have their own room, correct?
No, not in any way. That has never been disclosed to me. I understand that my youngest sleeps on the couch in an open office that is a shared space and not something that she's rented. I'd like to see the lease agreement where it shows that she rents 3 rooms, if so.
All right. Can you describe for me, in your period of possession, what kind of foods you're feeding the children in order to accommodate Braden's stomach issue?
They're all healthy choices. They contain the 4 food groups, I guess, so to speak. I mean, there's vegetables included with every meal. There's no fast food. It's very limited. We do maybe a fast food to give them a treat once every 3 weeks. That fast food is generally one of 2 things. It's either Chinese food or pizza. We're Italian, so we can't get away from the pizza, so to speak, but we definitely limit carbs and things that would cause high triglycerides and so on that have affected, when we were made aware of that, we had balanced meals, pre-planned, put together meals, healthy snacks for the kids. We changed the whole snacks. And I have pictures showing plenty of that within fridges and the pantries and always available to them.
Mr. Wolf, I need you to adjust your camera so that your face is within the Zoom box. And Ms. Wolf, I need you to do the same. Okay, thank you.
And are you aware, you did mention it, are you aware that Connor has high triglycerides?
That report was in 2022, I believe. When in fact it was stated as 2020 and I was made aware when I was not. So the triglyceride concern and the high levels were actually out of whack in 2022 and well in line with where they should have been in 2020. Along with 2021, they were actually even lower than they were in 2020, showing that there was no concerns with this triglycerides. It wasn't until the document that shows in 2022 that there was a concern with the levels. Sorry for making that long.
No problem. Your Honor, I'd like to introduce Respondent's Exhibit 6 into the record. And let's see if I do any better with sharing the screen.
Sure, you're gonna do better. Can't get much worse than me.
Is it Sharon? Can you see this exhibit?
Respondent 6?
Yes.
Yes.
Mr. Wolf, do you recognize this text message conversation?
I do recognize her words being written, but I don't see anything showing the actual doctor's information from the actual facility itself.
Do you see the date that these text messages were exchanged?
I do see that.
And you agree that the second set is from Monday, November 9th, 2020?
I agree that that is what she is informing me, but not what that it is, what it is, what it was with the facility.
And for the record, it reads, don't forget the 60. If it helps, the money gets withdrawn from my account on the first every month. Connor's triglycerides are high per doctor. He needs to cut pasta, white bread, sugary drinks, add omega-3 vitamins, 1,000 milligrams per day, and exercise 60 minutes per day.
Okay. So she has a habit of.
Hold on for a second. Pause. Do you agree that that's what that says?
I can read that as stated in that text message, yes.
Do you deny that you received this text message over 3 years ago?
No, I don't deny it.
Can you explain to me why you believe that he was only diagnosed with a triglyceride problem during the pendency of this case starting in 2022?
Because there's no medical record that shows otherwise. Where's the medical record that shows where his triglycerides were at in 2020?
So you're saying that you lied under oath that you requested and had access to those medical records?
No, I have the medical records. I just can't show them, unfortunately, because of the trouble I'm having. That's part of my exhibit. And they're in normal range with the document I have from the doctor's office. I apologize. Again, this is my fault, I guess, for the machine I'm working on and not being familiar. But I do have that record, and I do have it showing what those triglyceride levels were at that time in 2020, 2021, and I can show in 2022 where they were a concern. So I could speak to that text. I see the text, I can read it, but it's not correct.
What is not correct about this text?
The fact that she's saying his triglyceride levels are high per the doctor. They were in normal range.
Did you call the doctor?
No, I didn't call the doctor. It doesn't show, there's no notes saying that it was a heightened concern. This would be her creating that diagnosis of her own thoughts when she's not medically professional. She doesn't have a medical background to do so. But it's online. I mean, it's online in the ARC charts. Anyone can access it if you have access. And that's what I use to find the information that you're asking me today.
So let me clarify. So the respondent told you that his triglycerides were high. You have access to the doctor's office to get the medical records. You declined to call the doctor, but you don't believe what she told you because she's not a medical professional. Is that correct?
With the discretion of what she said in the past, absolutely. I don't hear it unless it's heard from the doctor. I don't take it as a guarantee. I will be concerned with it, but the levels were well in line with where they should be. And the fact that their levels in 2022 were much higher, and the fact in 2021 they were lower than 2020, I don't see how 2020 was a concern.
Do you have any sort of medical training?
I do not. However, I do show the levels were in the green where this notes triglycerides, and I can show by phone. I mean, I guess I could show by phone if that's admissible, where I'm accessing the panel for Connor. I don't know where the camera, I guess here. And it shows the triglycerides in green at 143. Now, if there's something from the doctor's office that's saying 143 is high and outside of the levels it should be at, I would assume, as the doctor told me, anything within the green is good, and at least not a high level concern. But obviously, there's ample opportunity to reduce that. But it's not to where it's a concern, as she's mentioning here, or something that would make it that I'm disregarding his health in any way. I thought, from what I understood, I believe it was like up to 150, and it says right here, up to 150 is in range. And he's at 143. So I don't understand why this has become such a focus, and you're using this as a means to show that I'm not being responsive or well responsive to that.
Well, then let's approach it differently. Can you tell me how frequently you call and schedule doctor's appointments with the doctors?
The only times I've done that is when they are sick, and they are not sick here. I do not have those things happen. And sicknesses often, I have a headache or something like that, are combated with simple over-the-counter medication. And I do ask them. I make sure that my boys are okay. I don't send them off to be in a state where they can't cope. And in fact, most of the time, if it's been a quandary between whether they should go to school or not, it's my son that's saying, you know what, I'll try, but if I can't, can I come home? Absolutely. And if you can't, make sure you see that nurse at the school before, so she can help us understand what's going on, and we'll get direction after that from the doctor, but at least we know ahead of time. And she has insurance on the kids. For the decree, she's responsible for covering the medical costs for our decree.
Well, according to the decree, aren't you 50% responsible for covering medical expenses as well as that premium?
It's not stated that way in the decree. And I carried insurance all the years that we had the children. And I never asked for reimbursement for the times I did take the kids to the doctor, even up to most recent when I had to get contacts for my son. I paid that all out of pocket. I never asked for any expenses back. That was during my time. I understood that. And I'm not saying that it's during her time, that, I'm just saying that I'm not trying to relevant or reference that's her time and my time. And there should be an absolute divide with that. I simply knew that this was my responsibility. I took it on, and I didn't ask for anything back because I knew the hardship she was going through anyway. I knew she wasn't going to be able to pay me. But her hardships don't fall because I've instilled that or I've not given her help. It's purely her own spending habits and things, but I won't veer from what the topic is. I apologize. So that is my answer, though. The triglyceride levels were within range. 2020, 21, they were lower. And in 2022, that's when they became a concern and out of the norm. Thank you. Sorry, I'm very passionate being Italian, but I mean no.
I'd like to introduce exhibit number 3 from respondents'
Sure.
exhibits.
Okay, did you offer R6?
I did offer R6 up. I'm sorry, Your Honor. I am getting a little turned around because we have a pro se party and I'm used to the procedure. I asked that R6 be admitted into evidence.
Any objection to R6?
If I could just familiarize myself with R6.
That's what was on the screen for the past 5 minutes.
Yes, well, absolutely. I have objections to that. I apologize, but I do have objections to the validity of that. Yes.
Well, state the objection.
Uh,
You have to have a legal objection to the admissibility of the document.
and validated contents, proof of other than text, or other than hearsay or authenticity.
Overrule the objection. R6 is admitted.
Authenticity, Your Honor. I apologize. I can't validate that that's the information that came from the doctor's office because I show otherwise.
The objection was overruled. The exhibit was admitted.
All right, let's take a look at respondents' exhibit number 3. Your Honor, I'd like to offer up exhibit 3, and let's see if we can more carefully set this foundation. So, all right, so this is an exhibit of text messages that you sent to the respondent on November 6, 2022. And let me see if I can get maybe a Zoom. Come on, zoom in for me. All right, this is a series of text messages sent by you November 6, 2020. Does this look familiar to you?
Yes.
All right. So you remember texting this, and these are messages that came from your phone.
Yes.
And you wrote this message.
Yes.
And this was in response to a request about what you guys were going to do about health insurance enrollment. Is that correct?
I'd want to familiarize myself because I wasn't aware of the content within what you guys were bringing. So if I could read the entire thread, that would be helpful to better answer that question.
All right, so you're saying that you do not recall and you need to refresh your memory as to the contents of this.
Yes, if you don't mind, please.
I have no objection to you doing so.
If you can scroll to the next page.
I'm only showing this to refresh your memory, not to do the entire extent of this,
Sure,
just
sure.
to refresh if you remember this
I
conversation.
remember what I'm seeing. Yes, what I'm seeing, I'm remembering that.
One at a time, please.
Yeah, thank you. So from this part, and we'll go through what's relevant here, and you'll have an opportunity to say if you believe something is substantially different from what you said, and then an opportunity to cross-examine Ms. Wolf, who is putting this into evidence on our side. In response to whether or not you were going to assist in insurance enrollment, this text is quoted, "I don't know what to tell you. My insurance enrollment is between now and the 13th of this month as well. But because you're deciding to be so heartless after I've been nothing but a perfect 50-50 co-parent and always meeting my obligations for covering half and even most of everything excluding this insurance that I've never been told an amount to pay, either don't worry, we'll figure it out, because if I put them on my insurance and I have to pay child support, I won't even have enough money to live off of. You make even more than me, even in one job, and you work 2 jobs. So before I agree to anything, I'm going to reach an attorney. I've got to get everything filed this weekend anyway to contest all this. It's just funny because you cheat on me. I try to forgive it, ask you to stop. You promise me you will keep. Then continuing doing it. So at that point, making it very clear that our family meant nothing. So I do with any person would do with a cheating spouse, and I file for divorce. I've worked with you over these almost 7 years cohesively and helped you out in many more ways. But want to make it so I can't live. And if you're trying to relate this to Sasha and what she may be doing in 5 to 7 years, should she become a doctor, there's nothing to say that this will even work out. So you're going to screw me for what? When we had the issue this last time, but the schedules, the kids were begging me not to have to go to court so I can see it after just a couple of days and do as you wanted. But now you want to drag them through this court. Great parents, selfish as fuck, considering, apologies, Your Honor, it was in the thing. If you get, and the fact that you make more than me and I've never once missed a commitment or not helped out in any way financially or thereafter what happened where you or need to hurt me financially after, and I promise we're almost done with this, after I've done what are the kids, because you realize that this affects the kids more than anything. I've never spent my money anywhere else but the kids. Everything I've been doing, spending money on has always been for the kids. So now I won't be able to do so many things with the kids, but yet you're without for the kids. Why? Because you refuse to do anything more with your jobs. Great, Mom. So until I hear from my attorney on what I should do, I'm unable to provide an answer until they have the ability to look at the entire case. And then the response is, the question is the same one I ask every year. If it's just easier, I'll keep them on my insurance. Do you agree that that is what you said in that exchange?
I agree that that is what I said in the exchange, with the understanding that she was responsible for the insurance. I was merely just trying to help out. Yes, I do.
And you see the following text at 12:30 a.m. I will have to speak to my attorney before answering. And following response, that's fine, but you only have until your enrollment period ends to decide. So do you agree with everything that you said in there? Do you stand by this?
I do.
So you believe you are a perfect 50-50 co-parent, no exceptions?
No, that matter of speech was not intended to be deluged or anything. It was a matter of speech. But no, I don't find myself a perfect parent.
You believe that asking for financial contribution to the children's health insurance is heartless. Is that correct?
No, otherwise I would not have carried it myself. I carried insurance for them all those years.
Well, you responded here that you said you're deciding to be so heartless after I've been nothing but a perfect 50-50 co-parent. And you agreed that the only question on the table was whether or not you were going to enroll the children. So my question is, what was the point of calling her a name if it's just a standard fare that you do every time because you're a perfect co-parent that pays for everything your kids need?
It was not, first of all, 2020. I mean, it was not my intention to say I was a perfect parent, and it wasn't my intention to use that direct verbiage to her. I mean, it's what is missing from this is that it included conversations beforehand over the phone or in person that made it so it was about a threat of, well, if this doesn't work, I'm just going to file child support. And it included her doing so in November of last year. But there's more behind this than just what is written on the text. I'm simply just saying, with everything that was said, both on text and not on text, I wanted to speak to someone else before putting something in writing, because there's a habit of spinning stuff as if I'm not trying to be understanding. I believe in anything, if I was required by the decree, that I would be covering it. It's not in the decree that I'm responsible for it.
All right,
And
counsel.
furthermore, I never got a bill.
We'll move
Oh.
forward. So request.
Excuse me.
Sorry.
It's time for our mid-afternoon break. We're
All right.
going to be in recess until 4 p.m. Until that time, you can mute and turn off your video.
I'm sorry, Your Honor, was the exhibit admitted before we go?
No, I interrupted you before you offered it.
Okay.
So you have to offer it after the break.
All right. Yes, Your Honor.
All right. right, it's 4 o'clock, so I'll give everyone a moment to turn their screen back on. All right, Mr. Wolf, we need you back. All right, Mr. Wolf, if you would go ahead and turn on your video again, we're ready to resume. Mr. Wolf, this is Judge Mangrum. I need you to turn your video on. It's after 4 p.m. We are ready to resume these proceedings. Ms. Holbrin, before you resume your questioning of the witness, I just want to remind you that if for some reason this hearing does not conclude by 5 p.m. today, it will need to resume tomorrow. You have a conflict in the morning, which in all likelihood would mean it would have to be after lunch. So you have witnesses you indicated may have a conflict with tomorrow. So you may want to keep that in mind as far as using your time, because the proceedings will not be rescheduled just due to witnesses' calendars.
Absolutely, Your Honor. We understand. We're prepared to produce evidence and testimony from various positions in case we do lose a witness. At this time, I'd like to ask for Exhibit R3 to be entered into evidence.
Okay. Any objection to R3?
No, Your Honor.
R3 is admitted.
And I'm going to try and progress a little forward because we have quite a bit of information that we have to get through that was not provided in pretrials. Mr. Wolf, how frequently are you late to exchanges or request a change in time for exchanges?
By late, define late, please, so that I can answer.
After the time you're ordered to be there, which is currently, I believe, 6 p.m.
There are times where I'm never over 15 minutes, except for maybe once or twice, but there are times where I'm 6:08, 6:09. Yes, ma'am. Traffic is difficult, and I don't rush my kids when they're having to grab things that's important to them.
So you understand, though, that you're ordered to be there at 6 and you were admonished to be there on time during the temporary orders period hearing. Is that correct?
For a text message that Jacqueline sent me, there's a 15-minute allotted window that she utilized.
Objection, non-responsive.
Sustain.
So you can't even recall my question.
I can recall your question. So according to what you're saying, being 6:08, 6:09, being late, yes, there are times I've been late. Absolutely. I can't help traffic.
I recall the question. You understand that you were ordered to be on time after this was mentioned previously about late exchanges, correct?
It was never brought other than Jackie to my attention, and I do try to make that happen as best to my ability.
And what is preventing you, other than traffic, from getting there on time?
Traffic, and if my kids forget something, which happens, and I have to drive back home, or if they're just, slower in getting ready. It's not in my intention. The 8 minutes or so, I don't get it. I always told her if I'm late 8 minutes, then be 8 minutes late to me. I don't care. I am not trying to be disruptive to what is required.
Are you saying you don't believe it's disruptive to the other co-parent to be late to exchanges?
I do understand that even a minute or two could be considered disruptive to anybody if they decide on that. Yes.
How often?
No, when trying to be there for that to be the case, and I'm always going to have that be my end and disrupted if that is the case.
How often would you say that you're getting the children returned to your possession late?
In agreed upon times?
No, sir, I'm saying late.
But
so you have, just to clarify my understanding.
I'm there a half hour early like she is.
Excuse me, for the record, please pause. We're talking about within the orders, you are permitted between you to make an agreement to adjust times and location. So I am specifically only asking, when agreement has not been reached, how frequently is Miss Wolf late to the exchange?
I couldn't count offhand. I would say less often than anything.
Do you appreciate, thank you. Do you appreciate her being on time?
Sure.
So let me ask you this. If the court decided from the evidence and testimony given in these proceedings that it was in the best interest of the children for Miss Wolf to have a standard possession schedule as primary, to have maybe joint conservator, sole conservator, that's a separate issue. But if there's a standard possession schedule, you understand that might result also in an order of child support, correct?
I understand that that could be the case. I would argue, other than on personal reasons, why that would be the case. Why? What could she use to require one standard visitation where I see less of my kids, and why that's a benefit to them? And I would like her to show how having that in place versus what we have now, 50-50.
Objection, non-responsive.
Overruled.
Okay. So maybe let me rephrase it just for you. I'm just trying to establish that you understand the way that these proceedings typically work is when we do a standard possession schedule, absent evidence of why we shouldn't, there's often child support, and wanted to establish that you know that. And you do know that. Yeah. Yes?
I do know that, and I know that when we started this, we agreed not to have that be the case. And I don't see why it should change.
Okay. If it is ordered that you pay child support, medical support, will you abide by that order?
Of course, I would have to. I would have no choice, and I would just argue the fact that I don't feel I should support what her mismanagement of money is causing. Both of us are single parents. Both of us are doing the same thing for the kids, but there's no reason to limit time or have me pay additional monies because of reasons that I can't control. And further, those medical bills and everything, I never received a bill for that, which is required. It's required within 10 days. I never received anything. It was just talk of what I owed. So that's all I'm going to say.
And you don't believe, let me ask you another question here.
Please.
In your divorce decree, you've read it, correct?
Correct. I'm not a lawyer, though. I'm a parent, okay? I know what's best for my kids and what's best in the contract. I understand to a degree and ask for help where needed.
Sir, I promise I will get to the point of the questioning where you'll have an opportunity to answer more fully. I'm just trying to set a foundation of the line of questioning so that it doesn't appear unreasonable and you know what I'm getting at. That's all. Within the decree, I understand that you're not a legal professional, but you would agree that you are literate and sufficiently understand the terms of the original decree.
Yes, ma'am.
Okay. Within the decree, do you remember it talking about rights and duties?
Yes, ma'am.
Okay. what duties do you believe as a parent you have under this decree?
How I understand it, and based on what has been told me by attorneys, I am responsible for these kids to make sure that they have everything that they need and are covered 100% when under my care. There's a 50-50 split, so that is my understanding, and that I would do anything if it came out of my care and was given to me the right way, like a bill. I've often asked for bills, if that's what you're referring to, but that yes, I understand, and I would understand this as under my time with the children, I am absolutely 100% responsible, which is why I carried insurance for them and things of that nature. So if something came up, I would utilize my resources I put in place to make sure that these kids have everything they need. And I would not ask the mother for anything in return. Yes.
And so, Brent, I just want to let you know, you've used about an hour of your time at this point.
Okay, and so we will have to conclude this side. Where I'm driving at with this is the hope of a more explicit duty here. Do you understand that as a conservator, you have a duty of care to the children, not just a right to make medical decisions, but a duty to get them medical care and let a doctor decide if they're in need of treatment and not decide for the doctor whether or not they need such treatment in advance and just forgo care?
If I'm knowledgeable of the treatment needed ahead of time, as it states in the decree that it's required, and I concede to that, which is also a decision that needs to be consented through me, absolutely. And I've never once not conceded to something that has merit or is valid, 100%. Even with the therapy, there's no issues other than the fact that she took him to therapy 3 times without me even knowing, and had a conversation with the therapist and disregarded what happens in our household so the therapist could have a full spectrum of what the environment is, both sides. If it's not, if something's not happening over here, it impacts what's being told to him that's happening, period.
Okay, so in the fall of last year, when Connor was still 12 and it was brought to your attention that he was exhibiting behaviors in front of adults, and it was a request to take him to a psychologist for an examination and make sure he wasn't suffering from abuse, I would like to know why you declined to give consent for that.
I worked with my attorney at that time, and it was my attorney that argued that point. It was a threat. There was a threat made from the people who brought that to light or made that accusation. I spoke to my child. I made sure that that was not the case. He absolutely was brokenhearted about it and stated very clearly that in no way, shape, or form would he do that in a living room, or he would do that at all. He admitted to having thoughts of doing that just as a normal teenage boy, which that's the progression of boys. And that's what my attorney mentioned. And it wasn't the fact that I refused therapy. It was the fact that she wanted to put him in therapy and attempted to without my knowledge again. And the only advice or statement that was made was, you need to check with us. And this is erroneous because there's no proof of this. And I'm not going to put my child through these proceedings and these allegations, interviews, when it's normal behavior for a boy. I'm sorry.
You believe that in front of adults is normal for a 12-year-old boy?
If done, no, but there was no proof that it was done. And Kevin and Lori had made threats to me in writing that watch what happens next with your family, because they felt I portrayed a negative outlook on their life that is only truthful. I had concerns. They were legitimate. I had reasons for those concerns. And because of that, they fired back with a threat that insinuated that they would attack my family or myself, and not in any particular way. So yes, when all of a sudden, a week later, that happened, and it's never been a habit, never happened here. It's never even been an interest of him. He is a boy that enjoys video games more than anything. He didn't even like girls at that point.
Are you aware that we expended over 8 hours of attorney time, exhausting all of the respondents' financial resources, battling over that issue, and that is why she was unable to afford legal counsel after that window of time?
Well, had she conducted the process the right way, according to the decree, and made me knowledgeable, and we were able to validate that in any way, absolutely, there would have been only an expense shared if that was the case. I've never refuted to share allowances. It's just she never came to me with a bill that's required, and I don't trust her spending habits and where that money would go.
So if I gave testimony today, since I participated in that attempt to get that during those hours, because I was limited to retain at that point, you do not believe that my testimony would be accurate if I said I personally requested and spent hours on the phone begging this other attorney to allow us to take this child for an evaluation, and was directed that you had declined and would not give any consent to psychiatric treatment of any sort.
I was not aware of the time you invested. I can understand your feelings behind that. However, where is the truth, and why is that, where's something that nothing was brought to me that showed validity with any of those accusations, especially when they came from two people that threatened me, and those behaviors have never been exuded at all.
Can you explain to me what the harm would have been meeting your duty and giving consent to the psychological treatment? What do you believe the harm would be for him to have gotten that evaluation?
Exactly what harm it brought when she brought him to therapy this time. She made him feel like he was solely responsible for causing this situation with his brother, when in fact there were other things behind that we know his brother, and his brother wasn't asked to go to therapy too. It's the way it's handled. It should have been that if there were concerns, especially interaction between the two, that both go into a therapy type setting so they both can find ways to constructively combat that and fix that. But in this case, there were only threats made. There was no validity. I'm going to talk to my son. And it was very clear that that was not the case, and that did not happen. I understand if there was anything brought to my attention that was true or could show a possibility of it happening, absolutely. It's just no one's nature to do something like that in the middle of a living room. It's just, and it's definitely not his habit or his trend or in his mind to do so. He feels insecure about being outside of his home. I don't see, there's too much that didn't add up.
If you're very concerned about how this process is impacting Connor, can you explain to me why he has awareness of today's proceedings?
He knows we're going to court. It's not something we could hide. This has been going on for so long. There's nothing more that we can say than, hey, tomorrow I'm going to go fight the fight for you. That's the best I can do. He's not giving details by me. I'm not going to put my kids through that. I try to avoid my fiance being brought into this.
So you're aware of the standing order that directs that you are not allowed to be speaking about these proceedings with the children, and that
I don't.
All right. So you don't know that the standing order directed you not to speak about this with the children?
No, he knows that I'm in court today fighting this case that has been made aware to him by his mother as well. And because his mother shares all this stuff with everyone else, it's in this world. They know what's going on. I'm not going to keep him in the dark that, hey, we're in a custody fight, or, we're in a custody dispute, and what happens in court is going to determine things. But I'm not telling him that this is going to happen or that, because I don't even know what's going to happen. I didn't expect for any of this to be the case. I don't know why we're here and fighting for what is good here. I'm only fighting for what I'm concerned with. I'm not even saying that I never refused medical payments. I never refused psychologists, anything like that. But I do ask for validity with things that are so impactful, because he is timid. He's scared. His mother was part of those sessions, sitting right there in front of him. It is stated in the psychologist's notes. It wasn't acted upon right. It wasn't a place where he felt free to talk. And the psychologist mentioned that, along with the fact that he's only comfortable talking to me. That's why he comes and shares this stuff with me. And I will never let that transparency go away. That's the bond I've created with my child, and it's consistently tried to be broken. And it doesn't do anything but hurt these kids. I don't understand why we're trying to argue differently on that.
All right, let's move forward, because there's some missing information that we have. During the last setting, we had some missing pretrial information that showed the schedule of your expenses. Should the court rule in your favor in the way that you've petitioned, and it is the court's discretion whether or not child support would be waived in that scenario. So Ms. Wolf has provided her financials. Were you ever able to file and provide your financial information prior to today?
My attorneys did file my financial information. It was given to you guys. It was requested back when I had him as counsel, and he provided that. We provided that to him.
Are you speaking about over a year ago?
I'm speaking when I had counsel and it was requested of me. I provided that documentation. Yes, ma'am.
All right, but for this hearing, for the final hearing that required you to do complete pretrials, and the clerk rejected the pretrials that you were submitted and completed, and you were noticed again before the last hearing in this one that it would need to be provided, did you have difficulty getting those numbers?
Yes. I'm not.
Are you currently employed?
I have started my own business. So I have my own business. It is in place. It is registered with the state. And because of the turmoil, I haven't been able to do exactly what I've wanted to do with going forward and making solid money with it. So I am in the process of doing this. So probably a bad time to start. But yes, I am self-employed. And the record I have is that of my paychecks from earlier this year when employed by an actual institution, which was the insurance company. And then I have record of rent that I get for the space that Sasha allocates or is a part of.
Can you just tell me what was the either biweekly or monthly amount when you were still employed by somebody else earlier this year?
It was roughly on a paycheck, $1,200 take home net pay.
Okay. And with it, that was per paycheck twice monthly. So would you say
Yes.
$2,400 a month? Okay. And then you said you were also receiving rents.
Yes, ma'am.
How much is that?
$1,600 a month.
So earlier in this year, you were netting $4,000 a year.
A year? No.
Or a year. I'm so sorry. $4,000 a month.
About that, yes, ma'am.
Okay. And for
For the
now,
months I was employed. I'm sorry. For the months I was employed with Progressive, yes.
I understand. And so now, how much money are you taking in a month?
It's honestly just that rental amount of $1,600.
And can you tell us what your profession is?
I opened up an insurance agency. So my profession is an insurance agent. I'm licensed in all states.
Okay. And was the amount that you were making earlier the year pretty standard of what you've been making in the past few years?
Relatively so. I mean, I was there for 4 years. So for the time that agrees, yes. The raises were minimal.
Okay. And do you anticipate being able to, running your own firm, get your income up to that $2,400 a month amount?
Absolutely.
How long do you think it's going to take you to start earning that from the new business?
There's just more involved with actually opening an agency. So I would say I'm at the end. I hope to get it all going by the first of the year. I really do. That's my goal. And to start generating money at that time. Absolutely.
Perfect. And you didn't quit your job during the pendency of these proceedings in order to artificially reduce your income, correct?
No, and then no, absolutely not. I was
Why-
simply. Oh, I'm sorry. Go ahead.
Why did you terminate your employment and not keep your employment while trying to get the business going?
There were concerns with the business that I was doing that I didn't want to be a part of. I chose to leave that company because if I had not, I probably would have had issues with opening up my own company, and I didn't want that.
And is there a reason you didn't get full-time employment to replace it while you were starting your business? Was it too time demanding? Why would you say that you're
I was
not?
still able to provide everything I need. I don't have a house bill or anything like that because of what I've been able to do in the past. And I've never once missed on anything that I, myself, or anyone in this household has ever needed. So my focus is more towards building the business.
So you have had, you believe, the funds to equally contribute to things like medical expenses or the premium copays, that kind of thing. but you declined to make those contributions timely because you did not receive bills as you believed you were entitled to under the decree.
The process with the decree was not followed, and therefore I was never given any ample evidence of what was needed to be paid and record of that being paid to that place that I was comfortable with. Correct.
So to be clear, you do not believe that your co-parent would tell you the truth.
No.
So even if she was 100% telling you the truth over and over, you do not believe that she would be telling you the truth. And so her word isn't enough to make a request. You would need those invoices and these extra steps in order for her to get reimbursement.
For these reasons exactly, yes.
Do you think that she arbitrarily enjoys scheduling doctor's visits for the children?
Enjoys, I don't see how that's relevant. I don't know how to answer. I don't want to give hearsay. I don't want to give an opinion on that. It's not.
She's a party, and you're able to give a present sense impression on why you believe that these doctor's appointments are happening that are not necessary. So what I'm asking is, what is the grounds for your basis that these medical expenses are not needed, or that she would be lying to you? What's your basis for believing that?
Because she's going around. I have documented circumstances where she is going around the doctor's diagnosis himself and using her own thoughts or thoughts of what the child needs to pursue other avenues, and it comes out to be, in fact, not valid. Meaning the avenues that she went to try and see if there was more, there was nothing there. So there was no reason to go that route.
But if you believe that, why aren't you calling the doctor's offices directly, since you have access to the medical records and can confirm with them directly? Why should I want?
Sure.
Why are you not calling and following up on that if that's your position?
I'm actually going as far as being a part of those appointments, which I had to do, in which she spoke for my son to the doctor. She clearly overrode what the doctor's statement was, that this is not a GI issue. And further, she allotted to or admitted to the fact that she was giving my son medication without his knowledge, all within that one meeting and appointment that I witnessed and was there for. So I made it a point to be a part of it. That was my concern.
So, I'm sorry, I think I have this wrong. So you've participated in just one doctor's appointment for which child?
First of all, I participated in the one doctor's appointment that I was aware of ahead of time, where I actually had the ability to be a part of before, as opposed to being told that this is what happened, or not being offered information as to when an appointment is or anything like that. So when I was told, and especially when it related to something like that, and I knew the reasons for those things because it had been a statement throughout the years with the doctor, and she was unwilling to change those habits. So I wanted to be present for that appointment so that I made sure that he was able to speak for himself, which was trouble in itself to be done. He wasn't even able to speak for himself. She was speaking for him on many occasions where I had to ask, please let Braden, he's 17 years old. He can speak to the doctor. Let him talk about his poop. Excuse me. But, so yes, that was a concern. And I was finally given information at that time because she was trying to keep everything level, which was great. That's what I want out of this. I want it to be open communication where I'm involved or have the chance to be involved, but I haven't had that opportunity before.
You have been a joint managing conservator since the time of the divorce. So if this was such a problematic situation, why did you not take over responsibility for scheduling these doctor's appointments and making them happen if you didn't approve of how it was being done by the other co-parent?
Valid question, because I was not informed until after the fact. That's the reason why. And when I was informed and I had the opportunity to do so, I took every step other than she has the insurance. They're under her, and in the decree. And if it's not about the payment, it's just a mere fact that that's under her time. So she took him to the doctor. I wouldn't schedule an appointment when it's her time and she's noticing these things or having these concerns. But if I have the opportunity to be there and be a part of it, I will be. And that was the only time. And I'm here and I've been fighting this fight for those reasons. And the reason for the motion of enforcement is because she's not providing that information to me ahead of time, and she's taken upon herself to do these things without telling me first.
Well, let's narrow this down to a very specific kind of serious example of one of your possession periods. Is it true that when Connor was, I believe the age is 4, but when he was much younger, that he got hit in the head with, I believe, a baseball bat or a baseball?
Okay, that it was in our backyard. The kids were playing. He ran up into my son's area while he was swinging a bat. Not hard. It was just like, like a practice, like just illustrating a swing, and it hit him in the back of the head. Yes, I did everything I could to, console him, make sure he was, coherent. There was no cognitive issues. There was no, his vision was on point. He cried for a bit, and he was fine. It shockingly enough, I was amazed too. But there was no. I watched over him those remaining times. He didn't fall asleep. He didn't feel like he was dizzy. There was no signs of anything further. So no, I didn't run and call an ambulance or take him to the ER. But I made sure that he was okay. If there were any signs, I would never hesitate. As a parent, like I said, I'm a parent before I'm anything.
Can you explain why his pediatrician still had signs of concussion 2 days later when Miss Wolf took him to the doctor after finding out about the incident?
Okay, that was never brought to me, first of all. I was never aware of that. And furthermore, I don't see how 2 days later, I mean, I'm not a doctor though, but I would want to know how they could say that I did not do what I needed to do at that time with no showing of any signs. I mean, I get the fact he was hit in the head. People fall. I've fallen and cracked my head open, but it didn't mean I had to be rushed to an ER and there were issues with a concussion. It was merely the fact that I needed to get staples or something, but
So Mr. Wolf, so you have access to the medical records. You say that you are participating. Can you explain to me why you're unaware of this situation?
I have not seen a medical record that talks to that at all, nor was I informed that he was even brought to or that was the case. I would expect that furthermore, I was just given access to the medical records, okay, because she didn't even provide my information to the doctor's office about contact when she should have, especially if she had insurance. I was never given her insurance information, so there was no way for me to check. When things got a concern of mine and I started seeing inconsistencies and troubles, and I had questions, I went and made sure my name was on there and I had that access. And during that time, no, I didn't go back 12 years ago, or 10 years ago. I didn't. To look and see if God at that moment was anything done. That was not my intention. It was never brought to me, so I was unaware. Okay, that's trying to make something out of nothing, and that's the only thing I can say. I mean, if she did her due diligence and informed me, believe me, I would have been concerned. I would have taken it myself. It wouldn't matter.
Did you tell her that he had gotten hit in the head with a baseball bat?
Yes, absolutely.
And did she request that you take him to the doctor to be examined for concussion?
No, she asked what happened. Was he okay? What took place? Was he injured? No, there's no visible injuries. He was cognitive. He was okay. He cried for a little bit and was fine and went to continue playing. I watched over him and
do you feel like that's representative of how you make care decisions about whether or not one of the children needs medical attention?
No, because if they need medical attention and it shows, I'm going to give them medical attention. Like I said, I carried insurance. I've never refused taking them on my own to go see a doctor, but under her, I'm not in control of that. She doesn't make me aware, so I can't be in control of that or knowledgeable of it.
Mr. Wolf, you were in possession of Connor, though. Why would she need to?
I stated when under my possession, I would have no problem taking him to a doctor because I carried insurance for them. It's never been a financial burden for me to have them see a doctor. There's never been a reason for me to do so that hasn't been, or that's been presented where I neglected to do so. That did not work with the doctor.
Well, Your Honor, I have additional exhibits that this witness would be able to testify to, but they're exchanges between both parties, and I feel like we've used a substantial amount of time here, so I'd like to pass the witness at this time.
Okay. All right, Mr. Wolf, Ms. Hilbron has passed you as a witness, so at this time, if you have any redirect, that is any additional testimony to respond to some of the issues that were raised on cross-examination, now is the time to do so, or if not, we'll move on to the next thing.
I appreciate that the council has not objected to stuff I've only been able to say and not show via the screen, so I appreciate that. But I also know that that testimony, without being able to show it due to technical difficulties, does not stand up, I'm sure. So at this time, I don't, because it would be only something that could be argued as hearsay because I don't have the ability to show it to the court. So I choose not to waste the court's time and understand that this is something I need to figure out.
Okay, did you try to work on the screen
I
share?
did. I really did, Your Honor. I'm really going to work tomorrow to get a different device. That's a 100% a goal, and to understand the Zoom on that device before coming into the hearing. I hope that with the testimony I've provided verbally, that I could just simply show the proof, and if it's argued, then it's argued, but just move that way versus having to explain it all again. I'm sure that no one needs to hear that or wants to have me repeat myself. So.
Okay, before we proceed on a couple of things that I want to make sure everybody is aware of. My court reporter has been struggling with this hearing. Everyone so far has done a poor job of speaking one at a time. And that goes for both Mr. Wolf and Ms. Hoprin. You've interrupted the court. You've interrupted each other, and you've done so repeatedly. That needs to stop. Also, Mr. Wolf, you have a tendency to speak very rapidly. My court reporter is trying to get an accurate record. I know I'm having trouble just keeping up with hearing you. I can't imagine how her fingers must be burning from trying to take all of this down. And at times, Ms. Hobron has also been somewhat difficult, occasionally, much less often than Mr. Wolf, but speaking fast. So I need y'all to be more cognizant and more respectful of the fact that during a Zoom hearing, once one person starts to speak, it cuts off the other microphone. It is physically impossible for her to hear, much less to record, two people speaking over each other. So I just want to interrupt you to express I'm very unhappy with the jobs that you're doing. I'm not sure it happens, and but I've interrupted several times to correct it, and you've ignored those corrections. So this is a final warning. I am in control of this courtroom, and if I find that you continue to be disrespectful of the court reporter, I have at my discretion the ability to handle it as I see fit. Okay? Do we understand the court? Mr. Wolf?
Yes, Your Honor.
Okay. Ms. Hobron?
Yes, Your Honor.
Okay. Thank you. All right. If I understand correctly, Mr. Wolf does not care to testify on redirect at this point. And Mr. Wolf, you don't have other witnesses to call in your case in chief?
No, Your Honor.
Okay. So you rest at this point?
I rest at this point, Your Honor, yes.
Okay. Ms. Hobron, you may call your first witness.
Your Honor, we are not sure who has survived the wait. Do we still know who's in the waiting room?
I do. Ms. Watson and Ms. Martinez are in the waiting room. All right. Ms. Martinez, this is Judge Mangrum. Can you hear me?
Yes, ma'am.
Okay, if you'd raise your right hand and be sworn. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. And before we proceed, can you confirm for the court that you have not had any conversations with either of the parties or with counsel during this hearing?
I have not.
Okay. And can you confirm that you were not watching the court's YouTube live stream?
I have not.
Okay. Ms. Hobron, you may proceed.
Ms. Martinez, how do you know the petitioner, Jeffrey Wolf?
I dated him.
What years were those?
2013 to 2019.
And did you cohabitate during this period?
Yes.
And how much of that relationship were you cohabitating with the petitioner?
About 5 years.
Do you have kids from a previous relationship?
I do.
And you have a possessory schedule with those children?
Yes.
Were those children staying with you while you were cohabitating with Mr. Wolf?
Yes.
How frequently was that?
Every other week.
Have you had the opportunity to personally witness the parenting style of Mr. Wolf?
Yes.
Did you know the respondent, Jackie Wolf, during this period of time that you were cohabitating?
Yes.
How did you come to meet Jackie?
I met her through exchanging the kids, doing holidays and birthday parties together.
Would you say that you routinely collaborated with Miss Wolf when it came to the children's schedules?
Yes.
And how active was Mr. Wolf in these activities?
He was active.
Were there certain activities where he participated more than others?
He was definitely there for like sporting events.
Did he ever schedule doctor's appointments?
Not that I'm aware of.
Did you have to schedule doctor's appointments for the?
No, I did not.
Sorry.
Oh, sorry.
Did you ever have to schedule doctor's appointments for Braden or Connor while they were in your possession?
No.
Did you or Jeff ever assist Miss Wolf in enrolling the children in school?
I'm sorry, can you repeat the question?
Sure. Did Mr. Wolf or yourself, while you were collaborating, ever enroll the children in school?
No.
And why was that?
Jackie did that.
And did you feel comfortable not having to schedule doctor's appointments for the children because Jeff would handle those appointments if they were necessary?
Jackie would.
During that window of time, did you find it easy to coordinate and work with Jackie with coordinating the needs of the children?
Yes.
Did you ever witness her saying anything negative about Jeff to the children?
No.
Were you witness to the injury to Connor when he got hit by the baseball bat?
I don't recall anything like that.
Do you remember when Braden started having stomach issues?
Yes.
Did Jeff ever tell you anything about the stomach issues?
No, that was conveyed to me through Jackie.
Did you have any reason not to believe that they were a serious gastrointestinal situation?
No.
Did Jeff do anything around the house to help Braden with his stomach issues?
No.
Did your food schedule change or increased activity, physical activity with the kids together, or anything like that that would potentially assist Braden with these stomach issues?
I mean, sometimes I made him something else because he wouldn't eat what I made for dinner.
Would Jeff make something else for him, or would he require Braden to eat whatever was made?
No, Jeff would help make something.
Was there any sort of penalty for making something different if Braden couldn't eat what was on offer?
No.
If the children were having issues with school, did Jeff resolve them?
Not that I'm aware of.
Are you aware of any situations personally where Jackie resolves school issues?
I know that boys would fall behind on homework at our house, and so she would spend a good amount of time working with the boys with homework.
Did you ever witness any incident where Jeff disciplined the boys?
Not that I remember.
Is that because the children were exceptionally well behaved, or there was just a general lack of discipline?
Maybe a lack thereof.
Were you allowed to discipline the children?
No.
And would he treat your children the same way that he was treating his children?
No.
How did he treat your children differently?
My kids got in trouble more. All three of them had to share a room, and each of his kids have their own room.
Did that create difficulties for the children while they were sharing the household?
Yes.
Do you think there's any been long-term consequences of your period of time cohabitating with Jeff?
No.
Did living with Jeff put stress on your co-parenting relationship with the father of your children?
Yes.
Why was that?
Different instances where, like, we might have broken up and gotten back together, and their dad didn't really approve of that.
Was there an incident where you and one or more of the children were locked out of the household?
Yes.
Can you please tell me what happened?
Went to a wedding for a friend and came back, and he had changed the locks.
And which children were with you?
My son, Kellen.
Were Braden and Connor there?
I don't remember.
And was there a reason that he changed the locks while you were out at a wedding?
I think we had gotten into an argument about something, but I don't remember what it was.
If the children had some sort of unique need while you guys were in possession, would that be something that you two would handle, or something that you would tell Jackie to handle?
I think Jackie would handle that.
Do you feel like she would accept help from the both of you if you offered to do more?
Yes.
Did you or Jeff ever offer to do more?
We have, yeah.
And what was that more? What did that look like?
Like, we would even go and help her clean her house because she was going to school full time and working full time, and she just needed help.
Do you feel like she needed help because she was overwhelmed with responsibilities, or because she was negligent?
Probably just overwhelmed.
Did it ever give you any concern about the health and safety of the children in her care?
No.
Was she flexible with any scheduling requests that you or Jeff made to change the possession schedule in a given week?
Absolutely.
Would you depend on her to be understanding and flexible?
Yes.
Was Jackie allowed possession during holidays when you first started dating Jeff?
No.
How did Jackie end up getting any sort of possession during holidays?
I insisted that she get to share the time.
And how long did it take before holidays started being shared?
I don't remember. Probably we got together in July. I would think maybe like the following year.
From your experience, is Jeff heavily dependent on Jackie handling the majority of responsibilities for the children's decision-making?
Can you rephrase that?
Yeah, from your experience assisting the two of them with co-parenting, was Jackie, is Mr. Wolf heavily dependent on the labor and time and effort that Miss Wolf puts into managing the children's affairs?
Yes.
Does he make that job easier or worse or harder for her?
More difficult.
Do you have an example that you can think of, or is that just a general things are harder to navigate with Jeff?
I think in general, like, I guess I can maybe say as far as like exchange times, like if we were supposed to exchange at a certain time, it never really was at that time.
Have you heard Jeff saying things about Jackie in front of the children that were disparaging or alienating?
Not that I can remember.
So you feel pretty comfortable that in general, at least during the window when you were with him, the parties were respectful of each other's roles as parents and didn't say things to the children in order to create a gap between their relationships?
Not that I can remember.
And it's completely acceptable if there are things that you don't remember or to the degree that you feel confident in your statements. If Jackie was awarded primary possession on a standard schedule, so she had the boys more frequently, do you think she'd be able to handle that responsibility?
Yes.
Do you think that from your experience with the boys, that would create significant hardship for them if the schedule was changed?
No.
In your experience, then the boys have proved fairly flexible with the changes in the visitation schedule in the years it's been going on.
Yes.
If the roles were reversed and Mr. Wolf was ordered to have greater access to the children and limiting Jackie's possession period, do you think he'd be able to accommodate those additional responsibilities?
Yes.
And do you think that in order to accommodate those responsibilities, he would require assistance heavily from both his paramour and Jackie in order to do that?
Yes.
And is your opinion on that, just establishing this is your present sense impression on this party, is your opinion based on your experiences of trying to work with the two parties and the division of labor there?
Yes.
All right, I pass the witness.
All right, Mr. Wolf, any questions you have for Ms. Martinez?
Yes, Your Honor.
Go ahead.
Ms. Martinez, can you tell the court, please, what you've told me over those years about how you thought Jackie handled her living situation and what her living situation looked like especially when we cleaned it?
I mean, it was not organized. I think after we helped her, it stayed organized.
Would you say that there was clutter to where it was a fire concern, especially up the stairway and within the exits of that apartment? Or a concern?
No, there's a walkway through there.
Sorry, repeat.
I do. There was a walkway.
Do you recall the roach situation and the severity of that? Or in your words, what would be the severity of the roach situation at the residence?
There were roaches, yes. But being in property management, roaches don't necessarily come from the source. It could come from other places. And I do believe that she did request to move from that residence.
Do you believe that she brought it to the apartment's attention enough times where as a parent you would feel that enough was done to justify the fact that it was years that she lived in those conditions?
I don't believe it was years, and I do know that she brought it to the attention of the maintenance.
Would you allow your children to be in that situation at that residence for that amount of time? that she was living there?
I don't think that she was negligent. I would.
The question more or less was, would you allow your children
Objection,
to?
Your Honor, calls for speculation.
Overruled. You may answer the question.
Can you repeat the question, please?
Yes, as a mother, would you allow your children to live in those conditions for the amount of time that Braden and Connor were left to be there?
Yes.
What was your opinion that you mentioned so many times to me about how Jackie handled her parenting?
Can you repeat the question or rephrase the question, please?
Sure. Would you say you had any concerns about Jackie's way of parenting over the time that you were with me?
No.
So you never brought up any concerns?
No.
Any lack of care, any lack of habits with food, any lack of providing for the children, especially
No.
when it comes to food? All right. Now, regarding the situation with the bedrooms, do you deny that before you even moved in, I mentioned reasons why I needed to keep those rooms theirs individually, and that I would allow any other shared space, or that I offered to create a shared space with what I could do for your kids when they were living here?
Yes.
You deny that?
No, I don't deny that.
Okay, sorry.
I thought the original question was if I understood that there were those stipulations when we moved in or whatever.
Do you feel that those stipulations were made because I cared less about your kids or wanted less for your kids, or which at the time were what I thought of as our kids?
Say that again.
Would you feel that I did that for any reason that do you feel I did that intentionally to differentiate my kids over your kids when I was explaining the reason why I needed to have that in place?
Yes.
Was it not your choice at that time that I brought forward this quandary that we, I guess, now have, and the feelings that you had? Do you not think you had a choice to decide to live there or not? Was it not your choice to come into this home with those conditions?
Yes.
What were the reasons why I relayed those requirements or needs that I had to absolutely keep that way?
Because you don't want things to change for your kids.
I don't know if I could speak to what I said, or the reasons, but it was the fact that my kids did not have a space of their own at their mother's, and that at your ex-husband's house, they had their own space.
No question asked. Narrative. Well, it's not really a narrative, but the party is going on a narrative instead of asking the witness questions.
Let me rephrase. Did I not state? Oh, I'm sorry.
That's fine. You can rephrase. I would say it does seem like we're veering a little bit off topic, Mr. Wolf.
I guess I'm speaking to the validity of her claim that I treated her kids differently, or I cared more about my kids than hers. I just want to speak to the fact that there were reasons for that.
Well, you're not testifying, so you can't do that now. You can ask her a question that you think might give the court some information about that, but I mean, I'm just not sure how relevant her kids versus your kids. Each party here has a motion to modify. There is a burden for either party to meet in order to have the court grant a motion to modify. And so that's really where we need to focus our efforts.
Sure. I will rephrase, Your Honor. I apologize. Ms. Martinez, was there ever a time that you could state where I was asked to be a part of something or help with something where I refused in regards to
No.
Jacqueline? Would you say that I ever turned down the ability to be a part of something or help with something if it was made known to me?
In regards to what?
A need for the kids, something that needed to be done for the betterment of them or for something that they needed, where I would have said or not been interested in helping.
No.
Okay, Mr. Wolf, I need to interrupt. It's 5 p.m. It's the end of our workday. So it does not sound like we are through with Ms. Martinez. So let's go ahead and discuss. Ms. Hobron, you have a hearing tomorrow morning at 9:45 in the morning. How
Yes.
long do you believe that will last?
I have not been given a specific time, but we're having to review about 20, 30 years of medical records. So at least 2 hours, at most 3 before it'll be concluded. So I should be, and I'll need a break. So that should be done no later than 1 p.m., the very latest.
Okay. I really don't want to start at 2, but I know it would be difficult to go back to back, so I'm not really sure.
It could be faster, but I did something similar with my father, and it took almost 2 hours for a regular claim. So
Okay, let's say we're going to plan that the hearing will start at 1. And if the hearing is still going at noon, I need you to email Ms. Seeger and let her know that. And then I can decide whether I will push the hearing to 1:30 or to 2. But in any case, it would be no later than 2.
yes, Your Honor. And I think that with the opportunity to do so much cross-examination with Mr. Wolf, that aside from our witnesses, I think that we can speed things up. And I don't know how much time I have left. I think it's only like half an hour to present myself.
It's a little less than an hour, closer to 50 minutes.
All right. Yeah. I think we should be able to wrap up everything we need to do, and I'll try and consolidate tonight to kind of narrow the issues so that we can be efficient tomorrow, and I will drink less coffee so I do not talk as fast.
Okay. All right. And Mr. Wolf, you can attempt to address the Zoom screen share issue this evening, see if you can figure that out. I don't have any advice for you. I'm not sure that I've ever seen what happened when you attempted to share. I have not seen that before. So I don't know if it's particular to your device that you're using or a version of the Zoom software, but have never seen that. So I'm unable to help troubleshoot it, unfortunately. So we will plan to resume tomorrow at 1 p.m., same Zoom link. Ms. Hobron, if you are still in the other proceeding at noon, you need to let Ms. Seeger know. Of course, when you email her, you must copy Mr. Wolf as well. Goes without saying, but a number of people forget that whenever you communicate with the court or the court staff, cannot be ex parte and everybody must be copied. So please remember that. And yes, before we resume tomorrow, let me say 2 competing motions to modify. The court inquiry is there a material and substantial change? I've heard a whole lot of testimony. I'm not sure that the focus has been on material or substantial change. Heard a lot of people one parent unhappy with the other parent. Both of you are asking to be sole managing conservator. Texas law has a very high benchmark to get to be appointed sole managing conservator. So testimony needs to be targeted towards the issues that you are trying to get the court to rule one way or the other on. That's all I'll say about that. Those are all things you can find in the family code, and we'll see you tomorrow afternoon. Any questions before we leave the proceedings?
No, Your Honor, thank you.
Mr. Wolf, anything from you?
No, Your Honor, thank you.
Okay. Everyone is excused until 1 p.m. tomorrow, and we'll see you then or at another time somewhere in between 1 and 2 if the court decided to push it.